Thank you so much, everybody. It's great to be here. So I teach at University of Massachusetts, and I got an email that said, well, I'd like to give a lightning talk, 2 minutes long. And so I was thinking, well, I'd like to talk about this subject, but I also enjoy using technology in the classroom. So I said, can I give 2 talks? And they said, sure. So my first one was how to use technology to improve your teaching. And so I started talking, and everybody was totally into it. They thought it was great. And then I said, okay, fasten your seatbelts. We're going to talk about genital cutting. And their jaws just dropped. Pleased to have a friendly audience and more time. Yeah, so I want to start talking about how I got into the movement, and I'll just talk from memory. It's sort of etched in my mind. And so my son was born in 1987, and my wife was nursing, and I was, in the middle of the room and just enjoying the peace and quiet and love of having, my son. And then I heard a voice at the door said, have you decided whether to circumcise your son yet or not? So I remember thinking, whoa, I never thought about that. And then thinking, oh, well, there must be some medical reason for it. And then I kind of visualized a, snip of a useless piece of skin. So he started talking to me, and he said, according to the American Academy of Pediatrics, it's not medically justified. He said, urinary tract infections, 1%, can be treated with antibiotics. And then he said, it slightly reduces the risk of penile cancer, but it's a rare disease in old age. And you can avoid penile cancer by washing the penis and not smoking. And then I believe he said it may slightly reduce the risk of some sexually transmitted infections. This was before HIV. And he said, but that's not a reason to circumcise because people can practice safe sex. So I figured, okay, the answer is no. But he kept talking to me. Then he said, well, some parents choose it for religious reasons. And then I said, I'm not religious. And then he said, well, some people choose it for cultural reasons, if it's common in the culture, which of course it is in the United States. And I was starting to get annoyed. So I said, I don't care what people in other cultures do. I was thinking of my son, who cares what other cultures do? And so then here's the, what really got me started in the movement. He said some parents choose it for aesthetic reasons. And I said, no, personal reasons. I said, well, what do you mean? He said, well, some parents choose it if the father is circumcised, they want the son to be circumcised. And I remember thinking, like, matching penises? And I remember thinking that there can't be any law that allows that. I started thinking back to torts class in 1983 and thinking, doctors have to justify operations, but he just told me it's not justified. So the whole thing was, threatening, confusing. Oh, I left out, my wife's a physician, makes every medical decision for the family. And I said, I need your help. Can you help with this? She said, you have a penis, dear, you decide. Sweetheart, she said, you decide. Yeah, so, this was all, very uncomfortable. And I'd say it took until now to fully understand what happened in that 2 to 3 minutes, 2 to 5. And what did I choose? Well, I'll let you know. We'll come back to this. Yes, so I have kind of a privileged background. I'm quite fortunate. I went to Dartmouth College, graduated Phi Beta Kappa. I went to Cambridge University, got a master's degree with honors. I went to Virginia Law School, where Samar is. I was on the Law Review and the Journal of International Law, and I published an article in the Law Review. So I became a partner in litigation in a Boston area law firm. Practiced law starting in 1983, but I actually like teaching and scholarship a lot more. So, Tim said, what's our wheelhouse? My wheelhouse is legal scholarship and writing legal arguments. So I've written 10 articles about genital cutting in the law, published in some leading journals. One is Journal of Law, Medicine, and Ethics, with Stephen Svoboda and Robert Van Houw. Then I published Circumcision is a Fraud in a Cornell Law Journal. Then last year I was awarded a fellowship to Cambridge University to do legal research, and I wrote 2 more articles there that I'm going to talk about. In fact, one of them is the basis for this speech. So, I'm a litigator. I was a legal advisor in the case against the American Academy of Pediatrics. The AAP moved to dismiss. The judge gave us a chance to amend the pleadings. He said, "You're alleging fraud. Tell me what they knew, when they knew it, how you know they intended to defraud the public." And so I spent 85 hours researching this, and I gave it to the lead lawyer, and he didn't use it. So then I went to the client and said, "Trust me, this is important." And he went to the lawyer who said, "Don't worry about it," and we lost the case. Now, I'm not saying we would have won it with my research, but that's no way to fight against the American Academy of Pediatrics. If you're going to take on the medical profession, you better have a lot of firepower and have a lot of money behind it. So I was lead counsel in a lawsuit against Commonwealth of Massachusetts. It was based on an article I wrote saying it's unlawful to use Medicaid to pay for circumcision. So I remember co-counsel and I, we found out who our judge was, and he was Jewish. And we're thinking, oh my gosh, we're going to lose. And it turned out the opposite was true. So I think this is really important to say. The judge was Jewish, but he's completely neutral. And he ruled in our favor in a 26-page erudite opinion. So it was a huge win. By the way, I didn't want to bring the suit, but Ronald Goldman, the psychologist, was going to bring it anyway by himself. So I figured it'd be better to have a lawyer. But anyway, we lost on appeal. When I went to argue on appeal, two of the judges, the men, they were just like this with their arms crossed. We're not even listening to you. And the decision, I don't really understand the decision. I think it's wrong. But unfortunately, it's a decision against us. So it's an example of how, you can bring a case and lose and establish bad precedent. I'm really proud to be co-counsel in this lawsuit. I work with Eric. We all know how wonderful he is. But it's been such a pleasure working with him on another lawsuit and this one. I used to represent him after his Harvard play, so I know him going back forever. We're friends for life. But he's a tremendous lawyer. So I'm going to call him Eric the Brave. And we're really lucky to have Lake to have joined us here, where he used the Equal Protection Clause to get marriage equality. The right of gay marriage in Oregon is a tremendous accomplishment. And he's very well, he's so well regarded. We're very fortunate. I'm going to call him Lake the Great. So then we have Sammer, who also went to Virginia Law School, so he must be good. And for Tuel, he's only half-baked. I mean, another year and a half, how good is he going to be? So he's Sammer the Hammer. So the title of the talk is, if your genitals have been cut, you can sue. What are the challenges? What are our rights, and what claims can we bring? What defenses will physicians and hospitals assert, and are they valid? And if they're not, then what? What is the deadline to sue? Must we bring a malpractice action somebody talked about? Can we win without a trial? Now, that's a new idea. How large might the damages be? I've never heard that discussed. And why should people sue if you've been cut? So, to be clear, this is a battle of David against Goliath. So no plaintiff has ever won a lawsuit, to our knowledge, in the world about male genital cutting. My talk is about genital cutting of males, females, and intersex children. So it's a pretty big problem if you've never won a lawsuit, called a novel legal theory. Judges hate that. So you don't just need a lawyer. I think you need a lawyer knowledgeable in this field. Everything we've talked about for yesterday, we all know this. In Spanish, I guess it's called consabido, or common knowledge. But you get another lawyer, they're starting from square one. So the defendants, they couldn't be more powerful. And, you know, I think they're desperate. Doctors were desperate enough to preserve male genital cutting that they issued truly astoundingly bad guidelines in 2012. And Jews are desperate to defend circumcision as a religious right. And in the Bolt v. Bolt case in Oregon, which John Geisker helped prosecute very successfully, Jewish associations gathered together. And they came like a ton of bricks. And they wanted to circumcise that boy so bad. The father was Jewish, and they didn't care at all whether he didn't want to be circumcised. You know, so these are very powerful defendants. People believe physicians, everything they say. You know, MD, surgeon. So there's a great article by Sarah Waldyke talking about how circumcision is a deeply embedded cultural norm. So in some countries, boys are circumcised in puberty when they think that's fine, but they think it's horrible that we circumcise boys in infancy. And then here it's the other way around. We think, well, how could you ever circumcise, you know, a boy around puberty? And then Michael talked about traditions, you know, in Africa that, you know, go back so far. So there's a huge amount of cultural bias. So Morton Frisch and a group of 38 European physicians and ethicists all said that the American Academy of Pediatrics 2012 guidelines were culturally biased. So I think judges may be culturally biased. So in fact, in the Hieronymus case in Florida that Martin was very helpful in, it was Judge Gillens, and his son was likely circumcised, and he just said, I just don't get it, like everybody's circumcised. So he just didn't get it. It was completely culturally biased. Interestingly, there was so much backlash. He got removed from that jurisdiction. I don't know if they were related. And again, there's this problem that you can't bring suit and lose and establish bad precedent would be very bad. In the law, we ask, what are the material facts, the ones that are of legal relevance? These seem to be, to me, indisputable facts. If you leave a child alone when they're healthy, it's unnecessary to cut their private parts. They're going to stay healthy. I mean, it's really important. There's a study by Sneppen in Denmark said that only 1.5% of boys are ever going to need to be circumcised. But Morten Frisch of Denmark wrote me just the other day, and he said the real number is 0.6%, and he explained why. I don't fully understand it, but even that might be high. So the answer is virtually never necessary. And so then, you know, if you cut somebody's genitals, I mean, it's irreversible. It's performed without consent. Sometimes not mentioned, it's over the objection of the child. You know, they may be an infant, but they sure make clear they don't want to be circumcised. And Martin has just made really clear that, you know, more than 99% of boys, you know, they're forced, the circumcision forced, they don't volunteer for it. And according to Robert Van Houw, 1 in 10,000 men volunteers to be circumcised. It can be inferred that no boy would choose it for himself if fully informed. So then it's extremely painful in every case. Robert Van Houw made affidavit that it risks more than 50 complications, including death. Not to mention psychological harm that we've heard about from some people. And it causes serious harm in every case. So we're transitioning then to what are the rights of the child, and this is something Michael touched upon yesterday, so there'll be some repetition. I find I need to hear things 3 times before I remember them, so I think it won't hurt. So on the left, there's a trio of rights that are related: the right to bodily integrity, the right to autonomy, the right to privacy. There's also a right to health and life, to be free from torture, cruelty, inhuman, and degrading treatment, to freedom of religion, and to equal protection, the basis of this lawsuit. So at first, my research was just about U.S. law, but U.S. law is derived from English law. It's part of the common law in all the English-speaking countries. Basically, the laws in the U.S. are the same as in other English-speaking countries. That's a lot of countries. But there are even more countries are civil law countries, and all of these rights exist in civil law countries. Those include Europe, Asia, Central and South America. You have a large part of the developed world. So in addition, these rights exist under international law. So international law is mostly by treaty, like a contract where governments agree to be bound by the treaty. But there's also something in international law called customary international law, and where most nations agree to something and they agree to be bound, then all the nations are bound. So, for example, the United States has inconceivably not signed the Convention for the Rights of the Child, but it still applies to the United States. What I'm leading up to is, what my conclusion is, all these rights are universal everywhere in the world. So the right to bodily integrity, as you can imagine, is the right to be left alone. The right to autonomy is the right to make decisions for oneself. And the right to privacy is the right to make intimate personal decisions for oneself. So this right to bodily integrity dates back to the 18th century in England. Blackstone, in his commentaries on the laws of England, discussed the inalienable rights of man. And he said that a person has the right to uninterrupted enjoyment of one's life, limbs, body, and health. It's the right to be free from physical interference. It prohibits even a minor contact if it is unwanted. Genital cutting is a profound violation of the right to bodily integrity. And the Council of Europe has expressed, quote, deep concern, and then it mentioned female genital mutilation, male circumcision for religious and non-medical reasons, and intersex genital cutting. So Attorneys for the Rights of the Child has translated international cases, and I read them all in the course of writing this paper, and they're all very favorable to us. They together talk about all of these rights that I just mentioned. So in 2013, the Swiss court said there's a right to bodily integrity in medicine, and it's an important right. The right to autonomy, it's the same as self-determination, liberty, or freedom, the fundamental value of the United States. So if you have a right to be left alone, you also have the right to make decisions about one's own body. Now, children also have these rights, but to respect the rights of autonomy of a child, you have to wait until they're adults. If you cut them when they're children, you violate their right to autonomy. Autonomy includes their case law in the U.S. saying it includes the right to elect treatment and to decline treatment, even if it results in death. In other words, every person has a right to say no to an operation they don't want. So this German case you heard about in Cologne, Germany in 2012, and it held that boys, it was a religious circumcision, by the way, and the court held that boys have a right to bodily integrity and self-determination. So the right to privacy, it's a subset of the right to autonomy, and it gives even more protection in intimate matters. I only just realized this in the course of writing the paper, so I hadn't thought of this since 2011. So there's a Montana court that said few matters more directly implicate personal autonomy and individual privacy than medical judgments affecting one's bodily integrity and health. Bodily autonomy is violated by a surgical operation, which is called an invasion of the body, imposed on me against my will. So this isn't just an operation when one's genitals are cut, but it's cutting one's sex organs and affecting one's sex life. So in my opinion, it definitely violates the right to autonomy. And, well, it doesn't matter what my opinion is. The European Court of Human Rights said that. They've interpreted the European Convention on Human Rights to encompass privacy as well as bodily integrity and self-determination, ensuring that individuals can freely exercise their autonomy in sexual matters. The right to health and life, it's actually part of the right to personal security. The International Convention on Civil and Political Rights states everyone has the right to life, liberty, and security of the person. It's also part of the Universal Declaration of Human Rights. It's simply the right to be safe. So genital cutting harms all boys and men and girls and intersex children, something that the American Academy left out in its 2012 guidelines. Genital cutting violates the right to health and life. There's also a right under international human rights documents to be free from torture, cruelty, inhuman or degrading treatment. Genital cutting, unless medically necessary, is all of the above. And in fact, the United Nations has stated that genital mutilation of all kinds constitutes torture, cruel, and an outrage on human dignity, and it called for an end to them. So freedom of religion is usually invoked by the proponents of circumcision, but in fact, it's one of the rights that children have from which it can be argued that they should not be cut. So the freedom of religion in the United States is guaranteed by the First Amendment. It's part of the Declaration of the Rights of Man in France, dating back to 1789 in civil law countries. It's part of these human rights treaties, Universal Declaration on Human Rights, and the International Covenant on Civil and Political Rights, So again, these cases in Europe are coming in very favorably for us. This Swiss case said, and it was a circumcision case, it seems justified to refrain from inalterably identifying the child with a particular faith. They didn't use the words, but basically they're saying freedom of religion protects a boy from being marked as belonging to a religion that they may later renounce. So this right to equal protection, that's the focus of this lawsuit. Again, it's a universal right under international law as well. It's the duty to treat people and sexes equally. Sex is a category that's entitled to so-called strict scrutiny. It's the most protected category. So what this means, if you're going to discriminate on the basis of sex, you need a very, very good reason to do so, such as biological differences. So an example is that women may have reproductive rights that men who can't give birth don't have. Male and female genitalia and intersex genitalia need to be treated the same way. Male and female genital cutting both have the same sacrificial origins as a way of sacrifice to the gods for a good harvest, for example, involving bloodletting. They're both advanced in ancient times for similar reasons, like suppressing sexuality and because it's so supposedly cleaner. The places they're performed are both usually the same throughout the world. You may not know that females' genitals were cut in the United States up until about 1950, so doctors advanced reasons for that too, just like they do for male genital cutting. The key point, I think, that Steve talked about yesterday and I didn't fully understand, maybe, as he said, a diagram would have helped. But the bottom line is that the male and female genitalia are identical in early gestation, and then they become analogous or homologous parts, which is to say very, very similar. So, for example, the foreskin of the penis and the clitoral hood, they're both highly sensitive, erogenous, and functional tissue. I conclude it's impossible to treat them differently from the legal perspective. Now we're into your remedies, if you will. So you're cut. What is it a crime, and what claims can you bring? You know, we've talked about how in 1997 the U.S. Congress passed a law making female genital cutting a federal crime. But interestingly, there are notes when Congress made that finding, and it said female genital mutilation is a statutory crime in 41 states. Congress said, It violates the girl's federal and state constitutional and statutory rights. What it was saying is it was already a crime. We didn't need to pass this law. We just wanted to make it really clear. So we passed this law saying it's unlawful and a crime unless medically necessary. So what I'm leading up to is if it was already criminal and male and female intersex genitalia must be treated the same, then so are all forms of genital cutting. So it constitutes criminal assault. So there was a 2006 circumcision case in Washington State where a father circumcised his son in a bathtub for religious reasons with a hunting knife. And the court was shocked, and it said it's a clear case of criminal assault. Genital cutting is also child abuse. There's an excellent article by William Brigman in 1984, 1985. It was a really great insight, and he said if you cut off living tissue from a healthy child, it's a case of child abuse. You can't justify it on medical grounds. It's unnecessary, and it's harmful. And so the bottom line is it's child abuse even if it's a pinprick of a girl's clitoris or genitalia. It's a federal offense under the U.S. Child Abuse Prevention and Treatment Act and the Victims of Child Abuse Act. So the Royal Dutch concluded correctly, when it comes to the integrity of the girl's body, no single compromise must be made. So what that means is a doctor, nurse, medical profession doesn't even have the right to touch a boy's penis unless they have a valid medical reason to do so. Any touching violates the rights of the child. All right, so the heart of it, what civil claims can children bring? So other scholars had written that it constitutes a battery. It took me a long time to sort of realize what all the claims were that you could bring, and even up until last year when I was doing this research. So a battery is defined as any harmful or offensive conduct. Genital cutting, as we said, harms all boys and men, and it's certainly an offensive and unwanted contact. So in addition, I hope you all can follow this, even if you're not lawyers, but I think so. I think these are all fairly clear concepts that you don't need buzzwords to explain. But you've heard the concept of fully informed consent, that, to be valid, a medical procedure must have permission of a person entitled to authorize it who is fully informed. And we all know that, we'll get to it, but doctors don't come close to fully informed parents about circumcision at all. So that makes the operation is legally invalid. It's a battery. Circumcising a boy or a girl by lay people constitutes false imprisonment. It's when you physically restrain somebody without a valid reason. It's intentional infliction of emotional distress. The definition of that is extreme and outrageous conduct or reckless conduct that causes plaintiffs severe or extreme emotional distress, which genital cutting does. So there's a 2015 case in England by Judge Sir James Mumby, and he said both male and female genital cutting can cause significant harm, and the latter is sometimes more severe than the former. Thus, genital cutting satisfies, well, he didn't say this, I'm saying this, satisfies the elements of intentional infliction of emotional distress. This is an important argument for us to make when people say female genital cutting is worse. Well, maybe sometimes it's worse, but male genital cutting removes half of the penile tissue, and it turns the shaft into an external organ. So it's really a radical deformation of the penis. So somebody yesterday talked about trust. This again, I realized one day this is a breach of trust. So a physician has a fiduciary duty to the patient. The physician has an even greater fiduciary duty to a child because a child's below the age of reason or decision making. So this imbalance of power is incredible. The physician has superior knowledge of medicine, and the infant can't even reason or speak. And the doctor has the power to do whatever they want to the child's body, restricted only by the rules of medical ethics and their conscience and so on. And physicians, it's an egregious violation of that trust. So there's a UVA professor, Hafemeister, he wrote an article called The Physicians Have a Fiduciary Duty to Just Say No to Services That Are Not Medically Indicated. And as Martin just said, in 1971, the American Academy of Pediatrics said there is no medical indication to circumcise a baby boy. Of course there isn't, they're healthy. And so Hafemeister says, well, this crosses a line that no physician is allowed to cross to operate on a healthy child. And he said, regardless of the explanation given for it. So boys, anybody whose genitals are cut by a physician has a breach of fiduciary duty. So I think lay practitioners also do. If you take control of somebody's body, you have a duty, to protect their health, in my view. But we took it out of the paper, just my paper with Stephen Svoboda. We just didn't want to raise a controversial issue. So it's also a case of unjust enrichment. So to establish unjust enrichment, a defendant must receive a benefit. The plaintiff suffers a loss, and the defendant can't justify it. So we've said genital cutting violates all the rights of the child. And the doctor, the hospital, the pharmaceutical and cosmetics companies all end up with the boy's foreskins. They don't have a right to it, and it's a multi-billion-dollar per year industry, that's for sure. Pharmaceutical companies don't do anything that doesn't involve billions of dollars. So we don't know the number. Martin says maybe it's going to get bigger later, but my guess is billions of dollars are involved, or they wouldn't be buying the foreskins. All right, so what defenses can we expect doctors and physicians to assert? It seems they fall into three categories. So one is specious or preposterous claims. The next claim is it's a parental right. We had questions about that. And the third one is it's medicine. Dating back to 1875 in the United States or thereabouts, doctors have given the most preposterous reasons for male genital mutilation. And one of the most egregious is that babies don't feel pain, which they argued until 100 years. It seems sort of obvious if you watch a child writhing in pain that they're in pain. So the next, as we've talked about, is prevent masturbation. Well, who has a right to prevent somebody from, enjoying their sex organs however they want to? But it's because of the puritanical influence. It's another reason that physicians were able to medicalize it by, that was essentially a fear of the day. Sex was a dirty thing, so doctors said, we can help with that. Then the claim is made that a baby won't remember. Well, you could justify anything by saying, well, a person won't remember it. So then the claim is, we get to it, that the doctor said to me, well, if we don't circumcise them now, we'll need to do it later. Well, that's untrue. That's somewhere between 0.6 and 1.5% are going to need it. Then the claim is made it's better in infancy. Later it's going to cost more, and, the boy will be awake, and you might need general anesthesia. So it actually might be better if you were going to do it at all later, because a boy could express his opinion, or a young man, and you could have general anesthesia, and also the foreskin will have separated from the glands by then. It won't have to be forced apart. The argument that it avoids embarrassment in the locker room, some countries are more intact boys than circumcised. It's going to happen. There's globalization. People move around. Make the son's penis match the father's, I think, is preposterous. And the opposition is anti-Semitic. So then the next claim is it's a parental right. So you may not realize this, or perhaps you do, but The real claim is that parents can do whatever they want for any reason or no reason. So according to the American Academy of Pediatrics, dating back to 1975, personal reasons are okay, meaning, the look of the penis. Cultural reasons, social reasons. I think at one time they talked about, social pressures or something, complying with pressure, maybe even the weather. Religious reasons, a bad reason to spite one's ex. And I've had to handle about 4 of those cases, and they're awful, where, the wife doesn't want the boy to be circumcised, and the ex wants them to be circumcised despite the ex. It's awful. It should never happen. But the bottom line is no reason is required. So do parents have that right? And the answer is clearly no. Well, in 2012, the court in Cologne, Germany said it violates the rights of boys to bodily integrity and self-determination. And then the court also said that the boys' rights supersede the parents' rights. So back in the US or anywhere, the rule is that when parents are acting as their legal representatives for the son, as their proxy, they represent the child. So it doesn't matter what the parents' preferences are. They have a duty, as Michael said, to act in the best interests of the child. That's the major rule about how children should be treated under the law. But also, there's absolutely no substance to the claim that a person has a right to modify another person's body other than for a valid medical reason. These individual rights that date back to the 18th century in England, they're rights that adhere to individuals. They're not a right they belong to individuals. You can't impose your right on somebody else. It's a non-starter. But let's talk about this religious right specifically. So for the same reason, there's no religious right to modify another person's body. Again, it's a non-starter. There was a famous case in Massachusetts, 1944, Prince versus Massachusetts, where a parent was having a child hand out religious leaflets on a highway, and the court said, that's dangerous. The child could get killed. You're not allowed to do that. And so yesterday, one of the speakers said that the state has a right to protect children over the right to religion. So in this Oregon case, Bolt v. Bolt, that John Geisker worked on, the father wanted to circumcise the boy for religious reasons, and the court interviewed the boy and found out he didn't want to be circumcised and stopped the circumcision. Now, it seems to me if there was a religious right to circumcise, he couldn't have done that. So a consensus seems to be building in Europe based on several cases I've read on Attorneys for the Rights of the Child's site that translated them, that there is no religious right to circumcise. It's very favorable for us. The Cologne case we've talked about. Then there was a 2013 Swiss court that prohibited a religious circumcision on equal protection grounds. By the way, the Supreme Court famously noted that human sacrifices could not be excused by religious belief, as an example. And then there was a UK case of religious circumcision of 2 Muslim boys. Sorry, the parents were Muslim. They wanted their children to be Muslim. And the court said, well, they have the right to decide when they become adults. All right, so then we get to the defense. It's medicine. So it has an array of medical benefits. That's what the San Francisco legislation said. An array of medical benefits? Like, what benefits? So the doctors have claimed since 1875 that it cures more than 100 diseases. And interestingly, it's often the disease of the day, fear of masturbation, or when tuberculosis was the biggest problem, or when syphilis was the biggest problem. So all these claims have been disproved. So the circumcision rate was falling, and in 2012, the AAP claimed new evidence shows that it prevents HIV. And so as Martin said, the Canadian study shows that it does not prevent HIV at all in the United States. But boys are not at risk of adult diseases. Even if it reduced it by 60% in absolute terms, which sounds great, that's only 1.3% in real terms. What that means is if you have sex with a woman who has HIV, you're going to get HIV and over time. and you'd better protect yourself or not have sex. So I've come to the conclusion that it has no medical benefits, not even potential medical benefits. A medical benefit would be a medical reason to choose it. There are no medical reasons to choose it. So in my view, it's not medicine. It's still violence after all these years, still crazy after all these years. So even if these claims are true, it doesn't benefit most boys or men. As we said, UTIs can be treated. Boys are not at risk of adult diseases. It's unproven whether it reduces penile cancer, and it doesn't reduce HIV in North America. But the whole idea of a preventive amputation of a body part is insane. I mean, if you cut off fingertips, they wouldn't become diseased, but then you wouldn't be able to use the fingertips. People like to use their fingertips. It's like scarification. Do we mark people's, heads? It's all crazy. So that sort of led me to conclude that circumcision is a fraud. So a fraud is any form of deceit where you tend to deceive somebody either through a statement or an omission, and the person relies on what you say, and they are deceived, and then harm results. So at first I was thinking, well, it's medical fraud, but then over time it became clear that this fraud permeates the entire sales cycle. There's false advertising, like saying it's a parent's right or it's good for your health. So targeting the helpless, it targets infants unable to object. Robert Darby, the great historian of circumcision, wrote. But it also targets mothers. The mother has just given birth, and they're often out of it. And so they're targeting somebody who's incapacitated. But moreover, even the fathers, they only give them a minute to decide, a couple of minutes. So that's duress. And then, as I said yesterday in answer to, when I asked a question, according to Intact America, physicians solicit parental consent 8 times on average. So it's badgering. So if parents say no, would you like your son circumcised? They don't give a reason. You say no. They keep asking. They just keep coming and asking. I mean, at some point, the parents fold. So that's a big reason that the circumcision rate is so high. What's this medical fraud? Says Martin said, well, first of all, they don't tell you anything about the foreskin. That's erogenous, functional. People like to have it. They understate the risks. They assign no value to the foreskin. So the AAP said the benefits outweigh the risks. And they left out the harm. They assign no value to it. Imagine saying like a preventive mastectomy is a good idea and leave out that women, value their breasts. And they certainly don't disclose the pain, the risks, the harms. A legal fraud is when you have a legal right and somebody tricks you out of it. And so the AAP should know by now that children have legal rights, but they argue they don't. They argue it's a parental right, and they argue they have a claim to do this when doctors absolutely are not allowed to operate on a healthy child. So that constitutes legal fraud. The first article I wrote was about how it's unlawful to use Medicaid to pay for circumcision. Medicaid only pays for surgery that's medically necessary. It does not pay for elective, cosmetic, experimental surgery. So in my view, all these, let me add, the doctors falsely swear on a form that it's medically necessary to circumcise the boy at birth or later, and they use false diagnoses, so they know they're lying. So it's a case of intentional fraud. And all these states, there's somewhere between 14 and 17 have ended coverage. All the other ones, they're enabling the fraud, although they may not know it. And the sale of foreskins, the parents aren't told. If the parents were told, they probably would say no. One day I was thinking, well, should it be the burden on the child to prove that a doctor defrauded them? That doesn't make sense. It's hard to prove fraud. You can prove it through circumstantial evidence, and some states' recklessness is enough. And I remembered this doctrine of constructive fraud. So it sounds fancy. What is it? Basically, a physician has a duty to justify every procedure. And if they can't do it, fraud is presumed. And the rule is to prevent unfairness. So children, and when they become adults, they don't need to prove intent to defraud. So this is a powerful tool. So let's revisit the pitch to me. So a doctor came to the door, offered it to me. Well, they're not allowed to perform it. It violates all the rules of medical ethics. They're only allowed to operate when it's medically necessary. They're not allowed to solicit it. I knew nothing about it, so it was unfair surprise. They took unfair advantage of me. My wife said, you decide. She was incapacitated. I remember now she had a really glassy-eyed look. She was out of it. And doctors know that, and they should know that because they need to know that when a patient signs a form that they're able to give consent. They target children unable to object, as Robert Darby said. He told me it's not medically justified. Then why the hell are you offering to cut off part of my son's penis? It's best performed in infancy. Well, it's best not performed at all. And he forgot to mention what the foreskin is, what circumcision is, the pain, the risk, the harms, and risk of trauma, regret, and anger. So I said no. Thank you. I'm very proud of that. Lucky, though. Lucky. Yeah, so when is the deadline to sue? So this is the second paper I wrote at Cambridge. I'm finding people coming forward and say, can I sue? And by the time they come forward and say, can I sue, the answer is always, you're too late. And I was thinking, well, how come they didn't come forward earlier? Well, they only just became intactivists, and they only just read articles like saying circumcision is a fraud. So in the Levine case, the start of it was somebody heard about my article, and then he said, it's a fraud. Well, tell me more, and then he brought a lawsuit. So there's this rule called the discovery rule, and it says that it would be unfair to force a person to bring suit or to say they're barred from bringing a suit before they discovered or should have discovered that they have a legal claim. So then I was thinking, well, what does somebody whose genitals are cut, what do they have to know to bring a suit? Well, first of all, they have to know they were cut. Now, it might seem obvious if your genitals were cut, but if you were an infant, you won't know that until some point when you discover it. And it turns out quite a lot of circumcised men don't know they're circumcised. Now, then you have to know you were harmed. And the AAP says it's not harmful. So most people don't know that they were harmed. They can still have sex. And then importantly, you need to know you were wrong, meaning you have some legal claim that you can bring. And what I realized, it's impossible to know that. Even if you've heard all the intactivists talk and heard about all of the lawyers talk, there's never been a case. Nobody's ever won. Nobody knows for sure they could win. And so I conclude anyone can sue anytime, no matter when they were cut. So I'm just finishing that paper up, but I hope to publish it this year. So next thing, somebody talked to Joe about malpractice action. It's reasonable to think you need to bring a malpractice action. And David Llewellyn, all of his lawsuits, the penis lawyer, they're malpractice actions. But I was thinking malpractice is when you do something negligently. You had the right to perform it, but you did it badly. But genital cutting or male circumcision, you're not allowed to do it. It's not part of your license. It crosses a boundary, as we've said, in fact, even into criminality, regardless of the reasons advanced for it. So in my opinion, they're not acting as doctors, they're acting as a layperson. So there is a problem if a statute says in order to sue a doctor for anything, you have to bring a malpractice action. It's pretty much black and white. But I think I would make this argument, if it ever needed to be made, it'd be better to bring a lawsuit where there was a malpractice as well, and then go through malpractice and bring these other claims. But in my opinion, the doctor's not acting as a doctor, but as a layperson. It's not a malpractice claim, and it's much simpler, fewer obstacles. So can I win without a trial? Yeah. When is genital cutting justified? So I was thinking, well, it needs to be medically necessary. But because it's such a violation of such a key right, it has to be essential to the child's health. And then if the child's old enough, the child has to consent as well. But if it can be deferred until adulthood, it has to be deferred in order to respect the child's autonomy. Unless those conditions are present, it's indefensible. And that's the title of the article that Stephen Svoboda and I just finished. Genital cutting is legally indefensible and grounds for summary judgment. Summary judgment, okay, it's a legal buzzword, but it just means there's no need for a trial. If you are a girl or a woman, you were cut, and you go to court and you say you want damages, is there a need for a trial? There's no need for a trial. You just say I was cut. They didn't have a right to do this. And a boy or intersex person could say the same thing. I see no possible defenses, so I believe there's a right to summary judgment to win without a trial. Then I was wondering, well, what could the damages be? And you can make this short, but, one's private parts, they're private, they're priceless, right? I think you would argue that it messed up your sex life, made you really unhappy. And I think the sky's the limit in the damages that people could win. I haven't fully thought through class action, but I think because genital cutting is indefensible, I believe a class action is possible at the right time. This isn't the right time. You need society to be on board, but I think a class action is possible. I looked it up quickly, and it seems if liability is clear and the only issue is damages, you could have separate hearings on damages. Why should a person sue? I being anybody's genitals are cut. One is to get compensation. You can never get, your full genitalia back. But also, George Denniston of Doctors Opposing Circumcision, he's firmly of the belief that unless doctors are held financially accountable, this will never stop. Just think about it. The study came out saying it removes the most sensitive part of the penis. Did the AAP care about that? Then the AAP's own committee said it can cause neurological damage. Don't cause pain to infants. Did they care? It doesn't reduce HIV. Did they disclose that? Boys can die. Do they care? I conclude they don't care about the health of boys and men, those who perform this. They only care about the money. And so lawsuits are the only way to protect the next generation. And then I think if we are able to stop male genital cutting here, it will help end female genital cutting around the world as well, and intersex genital cutting. So the good news is it violates many rights. You have many claims. European courts seem to be deciding in that favor. You can sue anytime. It's not malpractice. You have a right to win without a trial. So the bad news, these are unproven legal ideas. I'm absolutely persuaded they're correct, but you have to fight the fact that nobody's ever won a case. Powerful adversaries, judges inclined to be culturally biased, need a specialized lawyer, need a lot of money, and you can't afford to lose. So there's the last slide, which has, these are the 3 papers, or actually there's 4, that give backup for everything I've said today. So just email me if you like, pwadler2@gmail.com. I'd be happy to send you any of these papers. And that's it for the talk.
All right.